14. Disclaimers. 1. To the maximum extent permitted by applicable law, myspace is not responsible for and makes no representations or warranties or endorsements of any kind whatsoever, express or implied, as to a. the myspace services, b. the myspace content on or provided through the myspace services, c. the content or user content, including the accuracy and reliability thereof, d. the third-party content, e. the linked services, f. the functions made accessible on or through the myspace services, g. any products, services or instructions offered or referenced in the myspace services, and / or h. security associated with the transmission of information transmitted to or from myspace or others via the myspace services. 2. In addition and to the maximum extent permitted by applicable law, myspace is not responsible for any damage, injury or loss caused by users of the myspace services or by any of the equipment or programming associated with or utilized in the myspace services or linked services. 3. Profiles and linked services on, through or in connection with the myspace services may contain links to other websites or services. Myspace is not responsible for the content, accuracy or opinions expressed on such websites and services, and such websites and services are not necessarily investigated, monitored or checked for accuracy or completeness by myspace. Inclusion of any linked website or service on the myspace services does not imply approval or endorsement of a linked website or service by myspace. When you access these third-party sites and services, you do so at your own risk. Myspace takes no responsibility for third-party advertisements or linked services that are posted on, through or in connection with the myspace services or linked services, nor does it take any responsibility for the goods or services provided by these third parties. Myspace is not responsible for the conduct, whether online or offline, of any user of the myspace services or linked services. Myspace assumes no responsibility for any error, omission, interruption, deletion, defect, delay in operation or transmission, communications line failure, theft or destruction or unauthorized access to, or alteration of, any user or member communication. Myspace is not responsible for any problems or technical malfunction of any telephone network or lines, computer online systems, servers or providers, computer equipment, software, failure of any email or players due to technical problems or traffic congestion on the internet or on any of the myspace services or linked services or combination thereof, including, without limitation, any injury or damage to users or to any person's computer related to or resulting from participation or downloading materials in connection with the myspace services or linked services. 4. Under no circumstances shall myspace be responsible for any loss or damage, including, without limitation, personal injury or death, resulting from use of the myspace services or linked services, attendance at a myspace event, from any user, content posted on or through the myspace services or linked services, or from the conduct of any users of the myspace services, whether online or offline. The myspace services and your ability to access the linked services are provided as is, and as available, and with all faults, basis, and myspace expressly disclaims all warranties, express or implied, including, without limitation, the warranties of merchantability, fitness for a particular purpose, non-infringement, title, custom, trade, quiet enjoyment, system integration and freedom from computer virus. Myspace cannot guarantee and does not promise any specific results from use of the myspace services or linked services. Some jurisdictions limit or do not allow the disclaimer of implied or other warranty, so the above disclaimer may not apply to the extent required by applicable law. 15. Limitation on liability. 1. In no event shall myspace be liable to you or any third party for any indirect, consequential, exemplary, incidental, special or punitive damages, including, without limitation, lost profit damages arising from a. your use or inability to use the myspace services, including the content and myspace content, or linked services, or the performance of the myspace services or linked services, B. Any action taken in connection with an investigation by MISPAS or law enforcement authorities regarding your access to or use of the MISPAS services. C. Any action taken in connection with copyright or other intellectual property owners or other rights owners. D. Any errors or omissions in the MISPAS services technical operation, or E. Any damage to a user's computer, hardware, software, modem, or other equipment or technology, including damage from any security breach or from any virus, bugs, tampering, fraud, error, omission, interruption, defect, delay in operation or transmission, computer line or network failure or any other technical or other malfunction, including losses or damages in the form of lost profits, loss of goodwill, loss of data, work stoppage, accuracy of results, or equipment failure or malfunction, even if MISPAS has been advised of the possibility of such damages. Notwithstanding anything to the contrary contained herein, MISPAS's liability to you for any cause whatsoever and regardless of the form of the action will at all times be limited to the amount paid, if any, by you to MISPAS for the MISPAS services during the term of membership. The foregoing limitations of liability will apply even if any of the foregoing events or circumstances were foreseeable and even if MISPAS was advised of or should have known of the possibility of such losses or damages, regardless of whether you bring an action based in contract, negligence, strict liability, or tort, including whether caused, in whole or in part, by negligence, acts of God, telecommunications failure, or destruction of the MISPAS services. Some jurisdictions do not allow the exclusion or limitation of incidental or consequential damages of the sort that are described above, so the above limitation or exclusion may not apply to you to the extent required by applicable law. 2. Residents of California are entitled to the following specific consumer rights information. You may contact the Complaint Assistance Unit of the Division of Consumer Services of the Department of Consumer Affairs by mail at 400 R Street, Suite 1080, Sacramento, California 95814, or by telephone at 916-445-1254. Their website is located at http://www.governor3. Residents of the European Union are entitled to the following exclusion to the disclaimers or limitation of liability. Nothing in this agreement shall operate to exclude or limit our liability for death or personal injury caused by its negligence, fraud or fraudulent concealment, or any other liability which cannot be excluded or limited under applicable law. 16. U.S. export controls. Software available in connection with the MISPAS services. The software is further subject to United States export controls. No software may be downloaded from the MISPAS services or otherwise exported or re-exported in violation of U.S. export laws, including restrictions pursuant to the U.S. Treasury Department's list of specially designated nationals, the U.S. Commerce Department's table of denied orders, or the U.S. Export Administration regulations. Downloading or using the software is at your sole risk and subject to compliance with all applicable laws. 17. Arbitration and no class relief. Certain portions of this Section 17 are deemed to be a written agreement to arbitrate, pursuant to the Federal Arbitration Act and apply to all users of the MISPAS services, where the mandatory laws in their country of residence permit such arbitration. You and MISPAS agree that we intend that this Section 17 satisfies the writing requirement of the Federal Arbitration Act. Where arbitration is not permitted by the mandatory laws in your country of residence, the provisions of Section 17 shall apply to all relevant disputes between you and MISPAS. This Section 17 can only be changed or terminated upon mutual agreement. 1. Disputes. Any controversy, allegation, or claim between you and MISPAS arising out of or relating to the MISPAS services, the MISPAS content, this agreement, or any additional terms, whether heretofore or hereafter arising are disputes. First, try to resolve. If you or MISPAS becomes aware of a dispute, then you and we agree to send a written notice to the other providing a reasonable description of the dispute, along with a proposed resolution of it. Our notice to you will be sent to you based on the most recent contact information that you provide us. But if no such information exists, or if such information is not current, then we have no obligation under this section 17.1.1. Your notice to us must be sent to myspace LLC, 8391 Beverly Boulevard, number 349, Los Angeles, CA 90048, at Business and Legal Affairs. For a period of 60 days from the date of receipt of notice from the other party, myspace and you will engage in a dialogue in order to attempt to resolve the dispute, though nothing will require either you or myspace to resolve the dispute on terms with respect to which you and myspace, in each of our sole discretion, are not comfortable. Arbitration of most disputes. If we cannot resolve a dispute as set forth in section 17.1.1 within 60 days of receipt of the notice, then either you or we may submit the dispute to formal arbitration in accordance with this section 17.1, unless it is an excluded dispute, which will be handled in accordance with section 17.2. Arbitrator. Upon expiration of the applicable 60-day period and to the fullest extent permitted by applicable law, a dispute will be resolved solely by binding arbitration in accordance with the then current GEMS Comprehensive Arbitration Rules and Procedures of GEMS, Incorporated. GEMS procedures, rules, and fee information are available as follows. GEMS 949.224.1810. http://www.gems.com. Nature, limitations, and location of alternative dispute resolution. In arbitration, as with a court, the arbitrator must honor the terms of this agreement and any additional terms, and can award the prevailing party damages and other relief, including attorney's fees. However, with arbitration, A. There is no judge or jury. B. The arbitration proceedings and arbitration outcome are subject to certain confidentiality rules. And C. Judicial review of the arbitration outcome is limited. All parties to the arbitration will have the right, at their own expense, to be represented by an attorney or other advocate of their choosing. If an in-person arbitration hearing is required, then it will be conducted in the Metropolitan Statistical Area as defined by the U.S. Census Bureau, where you are a resident at the time the dispute is submitted to arbitration. You and we will pay the administrative and arbitrator's fees and other costs in accordance with the applicable arbitration rules, but if applicable arbitration rules or laws require myspace to pay a greater portion or all of such fees and costs in order for this section 17 to be enforceable, then myspace will have the right to elect to pay the fees and costs and proceed to arbitration. Discovery will be permitted pursuant to the applicable arbitration rules. The arbitrator's decision must consist of a written statement stating the disposition of each claim of the dispute, and must provide a statement of the essential findings and conclusions on which the decision and any award, if any, is based. Judgment on the arbitration decision and award, if any, may be entered in or by any court that has jurisdiction over the parties pursuant to Section 9 of the Federal Arbitration Act. No class action matters. Disputes will be arbitrated only on an individual basis and will not be consolidated with any other arbitrations or other proceedings that involve any claim or controversy of any other party. But if, for any reason, any court with competent jurisdiction or any arbitrator selected pursuant to Section 17.1.3 holds that this restriction is inconsignable or unenforceable, then our agreement in Section 17.1.2 to arbitrate will not apply, and the dispute must be brought exclusively in court pursuant to Section 17.3. Limited time to file claims. To the fullest extent permitted by applicable law, if you or we want to assert a dispute, but not an excluded dispute, against the other, then you or we must commence it by delivery of written notice as set forth in Section 17.1.1 within 1 year after discovery of the dispute arises, or it will be forever barred. 2. Excluded disputes. The following disputes constitute excluded disputes. Herender, I. Any dispute regarding any of Myspace's actual or alleged intellectual property rights. E. Disputes, to the extent that the laws of the state of California authorize may be brought in small claims court. And I. Legal action taken by Myspace to seek an injunction or other equitable relief in connection with any loss, cost, or damage, or any potential loss, cost, or damage relating to the Myspace services, any content, your user, content and / or Myspace's intellectual property rights, including such Myspace, may claim that may be in dispute, Myspace's operations, and / or Myspace's products or services, collectively, injunctive relief. First, try to resolve. If X, any excluded dispute arises, and Y, excluding excluded disputes involving injunctive relief, you and we agree to send a written notice to the other providing a reasonable description of the excluded dispute, along with a proposed resolution of it. Our notice to you will be sent to you based on the most recent contact information that you provide us. But if no such information exists, or if such information is not current, then we have no obligation under this section 17.2.1. Your notice to us must be sent to Myspace LLC, 8391 Beverly Boulevard, number 349, Los Angeles, CA 90048, Atten, Business and Legal Affairs. For a period of 60 days from the date of receipt of notice from the other party, Myspace and you will engage in a dialogue in order to attempt to resolve the excluded dispute, though nothing will require either you or Myspace to resolve the excluded dispute on terms with respect to which you and Myspace, in each of our sole discretion, are not comfortable. If we cannot resolve authorized excluded dispute as set forth in section 17.2.1 within 60 days of receipt of the notice, then either you or we may submit the excluded dispute to formal arbitration pursuant to section 17.1 only, if you and Myspace consent, in a writing signed by you and an officer or business and legal affairs representative of Myspace, to have that excluded dispute subject to arbitration. In such a case, and only in such a case, that excluded dispute will be deemed a dispute and shall be governed by section 17.1. In the absence of such agreement, section 17.1 shall not apply to excluded disputes, and sections 17.3 and 17.4 shall apply. Injunctive relief. With respect to excluded disputes involving injunctive relief, section 17.3 and 17.4 apply, and Myspace may institute such excluded disputes as authorized therein immediately. 3. Jurisdiction. Except to the extent that arbitration is required in section 17.1 or authorized in section 17.2, and except as to the enforcement of any arbitration decision or award, any action or proceeding relating to any dispute or excluded dispute may only be instituted in state or federal court in Los Angeles County, California. Accordingly, you and Myspace consent to the exclusive personal jurisdiction and venue of such courts, for such matters, /span greater than 4. Governing law. This agreement and any additional terms will be governed by and construed in accordance with, and any dispute and excluded dispute will be resolved in accordance with, the laws of the California without regard to its conflicts of law provisions. 18. Other dispute resolution where arbitration is not applicable. This section 18 applies to all users of the Myspace services if and only to the extent that the mandatory laws in your country of residence do not permit arbitration of disputes in accordance with section 17. 1. Section 18 disputes. If any controversy, allegation, or claim, including any non-contractual claim, arises out of or relates to the Myspace services, the Myspace content, this agreement, or any additional terms, whether heretofore or hereafter arising or to any of Myspace's actual or alleged intellectual property rights, collectively, section 18 dispute, then you and we agree to send a written notice to the other providing a reasonable description of the section 18 dispute, along with a proposed resolution of it. Our notice to you will be sent to you based on the most recent contact information that you provide us. But if no such information exists, or if such information is not current, then we have no obligation under this section 18.1. Your notice to us must be sent to Mispace LLC, 8391 Beverly Boulevard, number 349, Los Angeles, CON 90048, at Business and Legal Affairs. For a period of 60 days from the date of receipt of notice from the other party, Mispace and you will engage in a dialogue in order to attempt to resolve the Section 18 dispute, though nothing will require either you or Mispace to resolve the Section 18 dispute on terms with respect to which you and Mispace, in each of our sole discretion, are not comfortable. 2. Jurisdiction. The parties agree that the state or federal courts in Los Angeles County, California shall have non-exclusive jurisdiction of any Section 18 dispute. 3. Governing law. To the maximum extent permitted by the mandatory laws in your country of residence, this agreement, any additional terms in any Section 18 dispute arising out of or in connection with it or its subject matter or formation, including non-contractual disputes, will be governed by and construed in accordance with the laws of the California without regard to its conflicts of law provisions. 4. Limited time to file claims. To the fullest extent permitted by applicable law, if you or we want to assert a Section 18 dispute against the other, then you or we must commence it by delivery of written notice as set forth in Section 18.1 within 1 year after discovery of the Section 18 dispute arises, or it will be forever barred. 5. Injunctive relief. The foregoing provisions of this Section 18 will not apply to any legal action taken by Mispace to seek an injunction or other equitable relief in connection with any loss, cost, or damage, or any potential loss, cost, or damage relating to the Mispace services, any content, your user, content and / or Mispace's intellectual property rights, including such Mispace, may claim that may be in dispute, Mispace's operations, and / or Mispace's products or services. 19. Indemnity and waiver of injunctive relief. 1. Indemnification. To the maximum extent permitted by applicable law, you agree to indemnify, defend, at Mispace's election, and hold Mispace, its subsidiaries, and affiliates, subcontractors and other partners, and their respective officers, agents, partners and employees, harmless from any loss, liability, claim, or demand, including, but not limited to, reasonable attorney's fees and costs, alleged by any third party due to or arising out of or in connection with a. Your use of the Mispace services or linked services, and your activities in connection with the Mispace services or linked services. B. Your violation or anticipatory violation of any applicable law in connection with your use of the Mispace services or linked services, or your activities in connection with the Mispace services or linked services. C. A breach or anticipatory breach of this agreement or any additional terms. D. Any breach of your agreements, representations and warranties set forth in this agreement. E. Any content that you post on, through or in connection with a Mispace services or linked services. F. Information or material transmitted through your device used to access the Mispace services, even if not submitted by you, that infringes, violates, or misappropriates any copyright, trademark, trade secret, trade dress, patent, publicity, privacy, or other right of any person or entity. G. Any misrepresentation made by you, and H. Mispace's permitted use of the information that you submit to us, including your content, all of the foregoing claims and losses. You will cooperate fully as required by Mispace in the defense of any claim and losses. Notwithstanding the foregoing, Mispace retains the exclusive right to settle, compromise, and pay any and all claims and losses. Mispace reserves the right to assume the exclusive defense and control of any claims and losses. You will not settle any claims and losses without, in each instance, the prior written consent of an officer of Mispace. 2. To the maximum extent permitted by applicable law, if you claim that you have incurred any loss, damages, or injuries in connection with your use of the Mispace services, then the losses, damages, and injuries will not be irreparable or sufficient to entitle you to an injunction or to other equitable relief of any kind. This means, without limitation, that, in connection with your claim, you agree that you will not seek, and that you will not be permitted to obtain, any court or other action that may interfere with, or prevent the development or exploitation of any website, content, user content, product, service, or other intellectual property owned, licensed, used, or controlled by myspace, including your licensed content, or a licensor of myspace. However, you acknowledge that any breach or anticipatory breach by you of this agreement may result in harm to myspace, not capable of a remedy of money damages alone, and accordingly, in addition to any action at law for damages, myspace will be entitled to seek injunctive and other equitable relief. 20. Wireless. The myspace services may offer certain features and services that are available to you via your wireless device used to access the myspace services. These features and services may include the ability to access the myspace services features and upload content to the myspace services, receive messages from the myspace services, and download applications to your wireless device. Collectively, wireless features, standard messaging, data, and other fees may be charged by your carrier to participate in wireless features. Fees and charges may appear on your wireless bill or be deducted from your prepaid balance. Your carrier may prohibit or restrict certain wireless features, and certain wireless features may be incompatible with your carrier or device. You should check with your carrier to find out what plans are available and how much they cost, or any other questions regarding these carrier-related issues. You agree that as to the wireless features for which you are registered for, we may send communications to your wireless device. Further, we may collect information related to your use of the wireless features, including for the purpose of sending you targeted ads. If you enable GPS or location-based features in connection with wireless features, your device location may be tracked and shared with others, including advertisers, consistent with our privacy policy. Any such location-based wireless features are for your personal use only and should not be relied on as an emergency locator system used when operating vehicles or equipment, or in any situation where use distracts from safe behavior, or the failure or inaccuracy of the services could result in harm. If you have registered via the myspace services for wireless features, then you agree to notify myspace of any changes to your wireless contact information, including phone number, and update your accounts on the myspace services to reflect the changes. You may uninstall our applications to terminate the myspace services related to them. 21. Operation of myspace services, availability of products and services, international issues. 1. myspace controls and operates the myspace services from its U.S.-based offices in the United States, and myspace makes no representation that the myspace services is appropriate or available for use beyond the USA. If you use the myspace services from other locations, you are doing so on your own initiative and are responsible for compliance with applicable local laws regarding your online conduct and acceptable content, if and to the extent local laws apply. The myspace services may describe products and services that are available only in the United States, or only parts of it, and are not available worldwide. We reserve the right to limit the availability of the myspace services and or the provision of any content, program, product, service, or other feature described or available on the myspace services to any person, entity, geographic area, or jurisdiction at any time and in our sole discretion, and to limit the quantities of any content, program, product, service, or other feature that we provide. 2. By accessing or using the myspace services, you represent and warrant that your activities are lawful in every jurisdiction where you access or use the myspace services. 3. You and we disclaim any application to this agreement of the Convention on Contracts for the International Sale of Goods. 22. Software and User License Agreement. 1. myspace may offer the myspace services via software applications designed to run on specific operating systems, including, without limitation, mobile operating systems, including any updates and upgrades through TOS software. The software is myspace content. Subject to the terms of this agreement, myspace grants you a limited, non-exclusive, non-sublicensable license to use the software solely to access the myspace services. You are not authorized to use the software in any other manner. 2. Without limiting the generality of the foregoing, you must not allow any third party to modify, adapt, translate, alter, reverse engineer, copy, decompile, reverse assemble, disassemble, or create derivative works as defined by the U.S. Copyright Act, or improvements as defined by U.S. patent law from the software or the myspace services or any portion thereof, or otherwise attempt to discover any source code or in any way ascertain, decipher, or obtain the communications protocol for accessing the myspace services through the software. Remove or alter any trademark, logo, copyright, or other proprietary notices, legends, symbols, or labels in the software. Obtain or attempt to obtain unauthorized access to the myspace services through the software. Block, disable, or otherwise affect any advertisement, banner window, links to other sites and services, or other features that constitute a part of the myspace services as made available via the software. Incorporate, integrate, or otherwise include the software or any portion of it, including the communications protocols, into any other service, software, program, or product that communicates, accesses, or otherwise connects with a service or any other internet or online service other than as provided by myspace. Use the software in any unlawful manner, for any unlawful purpose. Use the software to operate any mission-critical application where human life or property might be at stake. The software and the myspace services are not designed for such purposes, and their failure in such cases could lead to death, personal injury, or property damage, for which myspace is not responsible. Sell, lease, loan, distribute, transfer, or sublicense the software, or access the rate or derive income from the use or provision of the software, whether for direct commercial or monetary gain or otherwise. Develop a skin or application for use in connection with a software that infringes the intellectual property or other rights of myspace or any third party. 3. You may install and personally use the software only in object code form on a device controlled by you for your own non-commercial use or benefit. Myspace may at any time and in its sole discretion revoke your license to use the software or suspend or terminate your access to the software without notice or explanation. If your license to use the software terminates, you must A. Remove the software from all hard drives, networks, devices, and other storage media, and B. Destroy all copies of the software in your possession or under your control. All rights in any third-party data, software, or intellectual property are reserved and remain with the respective third-party owners or licensors. These third parties may enforce their rights against you directly. 23. Other. 1. This agreement is accepted upon your use of the myspace website or any of the myspace services, and is further affirmed by you becoming a member and any continued access or use of the myspace website or any of the myspace services. Your agreement with myspace will always include this agreement at a minimum, except to the extent modified by another agreement to which we have mutually agreed. Your access and use of certain myspace services will require you to accept additional terms applicable to such certain myspace services in addition to this agreement, and may require you to download software or provide content. The failure of myspace to exercise or enforce any right or provision of this agreement shall not operate as a waiver of such right or provision. The section titles in this agreement are for convenience only and have no legal or contractual effect. Myspace is a registered trademark of Myspace LLC. Myspace TV is a trademark of Myspace LLC. Myspace may assign its rights and obligations under this agreement and any additional terms, in whole or in part, to any party at any time without any notice. This agreement and any additional terms may not be assigned by you, and you may not delegate your duties under them without the prior written consent of an officer of Myspace. This agreement operates to the fullest extent permissible by law. This agreement represents an agreement between you as a user, or if applicable, member of the myspace services and us as the service provider, and no other person can enforce any of its provisions against myspace. This agreement, and the documents referred to herein, including, without limitation, additional terms, constitute the entire agreement between you and us in relation to the use of the myspace services, and replace and extinguish all prior agreements, arrangements or undertakings of any nature made by the parties, whether oral or written, in relation to such subject matter. 2. If any provision of this agreement is unlawful, void, or unenforceable, that provision is deemed severable from this agreement and does not affect the validity and enforceability of any remaining provisions. If the remainder of the provision is not affected, we reserve the right to make lawful and reasonable variations to this agreement which may be necessary in order to achieve, to the greatest extent possible, the same effect as would have been achieved by the provision or part in question that is deemed to be unlawful, void, or unenforceable. 3. To contact us regarding any questions about this agreement, please use the Contact Myspace form on our alt site. Speakonia instruments.